It is day 5 in the pretrial hearing concerning the murder of Drew Peterson's third wife. The ex-Illinois police officer is accused of killing Kathleen Savio back in 2004. This hearing is to determine whether hearsay evidence may be allowed during the trial. Much of that hearsay, ironically, has nothing to do with Savio, but rather with the disappearance of Peterson's fourth wife, Stacy. Today, the minister who counseled Drew and his fourth wife is taking the stand. And let's bring in criminal defense attorney Thomas Glasgow right now to talk about all of this. Thanks for joining us. So the minister says Stacy told him that her husband killed his third wife, Kathleen. But he is a minister, and Drew's lawyers say his testimony can't be allowed because of that religious aspect. Does he have a case there?
Well, the judge did exclude marriage counseling between Drew and Stacy. He also excluded any conversations between Drew and the minister, but allowed conversations between Stacy and himself at a coffee shop. So they ruled that the exception to that, the privilege, did not apply to that particular situation. So if this conversation where he said that his husband killed Kathleen happened at the coffee shop, but you believe that will probably be admitted at the trial? The judge, after careful determination of the case law, determined that that was not a protected or privileged conversation, and therefore he allowed that particular portion in. Also at this hearing, a neighbor dramatically testified that Stacy was convinced that Drew wanted her dead. Let's pull up that quote right now from what she said. She said to her neighbor, "Drew won't go. He won't leave. If I disappear, Sharon, it's not an accident. He killed me." And again, that's what we saw in court by Sharon Bykowski yesterday. So do you believe that that type of hearsay will be eventually admitted or excluded? Well, the particular hearsay exception that we're dealing with here has to do with the fact that the person who ended up arranging or absenting the person who made the statement from testifying in court. I think that under the law, the way it's written, that statement is going to come in. The judge has already ruled that this particular statute is constitutional, that it's admissible if they meet the standards under the statute. The question really is the judge going to find that Drew Peterson took the steps to make the witness unavailable, and is the statement reasonable and reliable for the exception under hearsay? So even if it is permitted, I mean, the defense will presumably argue that the relationship with his fourth wife is not relevant to what happened with his third wife. I mean, you're saying the way around it is by saying he tried to make her unavailable as a witness, but he wasn't charged in Kathleen Savio's murder until after his fourth wife disappeared. So doesn't that idea of her being a witness that was trying to be eliminated, isn't that sort of tricky? It is tricky, and it becomes a circular argument. You've got Kathleen Savio's death, for which he's charged, and you're utilizing statements from a disappearance, Stacy, to help prove up the case against Kathleen Savio that Drew Peterson actually killed her. There is not a great deal of physical evidence in this case, and the statements that are being used from Stacy Peterson are being used to then bolster that argument that Kathleen Savio was killed by Drew Peterson. And repeatedly we see statements from Stacy and from others that go back to Drew Peterson. Now, the statements that are being made directly towards Stacy Peterson, that she was going to be killed, that she was going to end up being eliminated somehow by Drew Peterson, may be more prejudicial than probative, and therefore the judge may not allow that in. Remember, they're putting in some 60-odd witnesses today during the course of this hearing. Yeah. Today we've heard from the minister, yesterday we heard from the minister, and we're going to hear from a lot more. This hearing is not going to be over overnight, and we're going to be hearing things that some of which may be admitted, some of which may not be admitted, and the judge may split the baby in this matter, just to make sure that the reasonable and reliability of the statements is covered by the statute and his findings. Yeah, this pretrial hearing could end up being as long as a trial. Thomas Glasgow, defense attorney, thank you for joining us. Right. Well,